An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman.
The 11th Amendment, Hans versus Louisiana, 1890, and Seminole Tribe of Florida versus Florida, 1996. In Chisholm versus Georgia, 1793, the Supreme Court considered whether a South Carolina citizen can sue the state of Georgia. 4 justices held that the states were not sovereign and could be sued in federal court without their consent: Blair, Wilson, Cushing, and Chief Justice Jay. Justice Iredell, the lone dissenter, found that states as sovereigns had not surrendered their immunity from being sued without their consent. The Court's decision was met with widespread opposition by state governments. 2 years later, the 11th Amendment was ratified. It modified Article 3, Section 2 of the Constitution. Originally, the judicial power expressly extended to controversies between a state and a citizen of another state. Now, while a state can be a plaintiff against another state or a citizen thereof, a state cannot be a defendant in a suit by a citizen of another state unless it so consents. The text of the 11th Amendment answered some questions but left many other questions open. First, could a citizen of one state sue another state? That is, could a resident of South Carolina sue Georgia? The answer is now clearly no. Second, could a citizen sue his own state? That is, could a citizen of Louisiana sue Louisiana? The text does not address that question. Third, did the 11th Amendment reverse Chisholm's majority's holding that states lack sovereign immunity? Again, the text does not address that question. These final 2 questions would be resolved a century later by Hans versus Louisiana, 1890. Following the end of the Reconstruction era, the state of Louisiana failed to pay interest on certain bonds. Hans, a citizen of Louisiana, sued Louisiana in federal court. He claimed that the state had violated the Contracts Clause, which forbids a state from impairing the obligation of a contract, thereby giving rise to a federal question. Study guide. Does it make a difference whether a citizen sues a state based on federal question jurisdiction or on diversity jurisdiction? Justice Bradley, writing for a unanimous court, acknowledged that the text of the 11th Amendment does not prohibit a citizen from suing his own state. It only applies to suing another state. However, he said, this reading would lead to an anomalous result, where a state could be sued by its own citizens, but not by foreign citizens. Justice Bradley concluded that, quote, "It is inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent." The Hans Court answered the 2 questions left open by Chisholm and the 11th Amendment. A citizen could not sue his own state without its consent because the states were sovereign. Study guide. Does the text of the 11th Amendment say anything about sovereign immunity? Did the 11th Amendment correct a mistake in the original Constitution, or does it correct the Supreme Court's mistaken interpretation? Justice John Marshall Harlan concurred. He agreed that, quote, "A suit directly against a state by one of its own citizens is not one to which the judicial power of the United States extends unless the state itself consents to be sued." However, he stated that Chisholm, quote, "was based upon a sound interpretation of the Constitution prior to the ratification of the 11th Amendment." In other words, he thought it was the Constitution and not the court that needed to be corrected by an amendment. In our second case, the Seminole Tribe of Florida sued the state of Florida pursuant to the Indian Gaming Regulatory Act. The 11th Amendment prohibits citizens from filing lawsuits against a state in federal court. In Chisholm, the Supreme Court held that the states have sovereign immunity from citizen suits. However, there are 2 ways a citizen can still sue a state. First, a state can waive its own sovereign immunity by consenting to citizen suits in federal court. State governments, like the federal government, have enacted claims acts that enable some types of citizen suits. Florida, however, did not waive its sovereign immunity in Seminole Tribe. Second, even if the state does not consent to citizen suits in federal court, Congress has the power to override or abrogate a state's sovereign immunity. Through that Indian Gaming Regulatory Act, Congress attempted to abrogate Florida's sovereign immunity, but could it? In Seminole Tribe, the Supreme Court held that Congress cannot abrogate a state's sovereign immunity pursuant to its powers under the Commerce Clause. Chief Justice Rehnquist, writing for a 5-4 majority, relied on Hans versus Louisiana for two propositions. First, that, quote, each state is a sovereign entity in our federal system. And second, that, quote, it is inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent. From these two premises, he concluded that the Indian Gaming Regulatory Act was unconstitutional. Quote, even when the Constitution vests in Congress complete lawmaking authority over a particular area, he wrote, such as the regulation of interstate or Indian commerce, quote, the 11th Amendment prevents congressional authorization of suits by private parties against unconsenting states. Justice Souter wrote a lengthy dissent about the history of the 11th Amendment. On its face, he explained, the text appears to limit only the Article III diversity jurisdiction of the federal courts. Article III specifically refers to a citizen of one state suing another state, which is what makes the parties diverse. The text of the 11th Amendment does not reference their jurisdiction to hear cases involving federal questions, such as whether the Congress has exceeded its commerce power. According to Justice Souter, quote, we have two 11th Amendments, the one ratified in 1795 and the other so-called invented by the court nearly a century later in Hans versus Louisiana. Chief Justice Rehnquist responded to Justice Souter's argument by invoking not the text of the Constitution, but its underlying principle or presupposition. Quote, although the text of the 11th Amendment would appear to restrict only the Article III diversity jurisdiction of the federal courts, we have understood the 11th Amendment to stand not so much for what it says, but for the presupposition which it confirms. According to Rehnquist, quote, federal jurisdiction over suits against unconsenting states was not contemplated by the Constitution when establishing the judicial power of the United States. Study Guide. Who was being the originalist here? Is it Justice Souter for relying on the original meaning of the text of Article III and the 11th Amendment, or Chief Justice Rehnquist for relying on what was contemplated by the Constitution? Regardless of what the 11th Amendment says, however, the court later held that Section 5 of the 14th Amendment expressly gave Congress an enumerated power to override a state's sovereign immunity. However, there are limits on when Congress can exercise that power. We will discuss this issue in City of Burney versus Flores, 1997.